Welcome back to the deep dive. Today we're getting into some pretty specific twists and turns in the patent appeal process. We're looking at what happens after you've done the initial back and forth with the examiner.
That's right. We're continuing our journey through the MPP section by section. Today is Chapter 1200, Appeal.
And specifically.
We're focusing on what happens after the examiner issues their answer, and maybe you filed your reply brief, how things move with the Patent Trial and Appeal Board, and, crucially, digging into MPP Section 1206.
1206, that's amendments and affidavits or other evidence filed with or after appeal? Sounds like rules about what you can file and when.
Exactly. It's mostly governed by 37 CFR 41.33. And, well, understanding these rules is absolutely critical. It dictates what you can actually do with claims or evidence once you're on the appeal track.
Okay, let's unpack this. So set the scene for us. You've filed the notice of appeal, the examiner sent their answer laying out the rejections, and maybe you've just filed your reply brief. Where is the case, like officially at this point?
Okay, so once that reply brief is properly filed, following 37 CFR 41.41 jurisdiction, generally speaking, passes to the board.
Right. So the file basically moves upstairs.
You could think of it that way, yeah.
And the examiner, are they pretty much out of the picture now?
For the most part, yes. They usually don't have to formally acknowledge the reply brief. And this is important, they typically won't get another chance to comment before the board makes a decision.
Okay.
And this is where those Section 1206 rules really start to bite. Because once that appeal brief is filed, and by extension the reply brief, making amendments gets really restricted.
How restricted?
Well, according to 1206, you're mostly looking at things like canceling claims, or maybe rewriting dependent claims into independent form, provided you don't add any new subject matter, filing new affidavits or other evidence. Generally, that's a no-go at this stage unless some very specific exceptions apply.
Okay, that sounds pretty tight. But here's where it gets interesting, right? What if the board doesn't just issue a decision? What if they look at it and think, we need the examiner to weigh in again?
Yeah, the remand. That can definitely happen. The board can absolutely send the case back down to the examiner.
For what reason, typically?
A common one is for the examiner to put together what's called a substitute examiner's answer. It needs to respond to whatever the board pointed out in the remand order. This is really the main way an examiner gets another shot at commenting after jurisdiction has already passed to the board and the reply brief is in.
Okay, so the case goes back downstairs. The examiner issues this substitute answer. What happens then? What are the applicant's choices? You can't just ignore it, I assume.
Definitely not. When you get that substitute examiner's answer, a clock starts ticking. You've got 2 months.
2 months to do what?
To choose one of two paths, basically, if you want to avoid having the appeal dismissed. And that 2 months starts from the mailing date of that substitute answer.
Got it. What are the paths?
Path number 1, file a reply under 37 CFR 1.111. Doing this is basically asking to reopen prosecution before the examiner.
So you're essentially hitting pause on the appeal and going back to arguing directly with the examiner.
Exactly, like you would in regular prosecution, at least for those specific issues. Path number 2, file another reply brief, this time under 37 CFR 41.41. This tells the board you want to maintain the appeal.
Okay, so stick with the appeal track, but now based on the updated record with the substitute answer.
Precisely. You want the board to proceed with its review.
Okay, seems straightforward enough to
Right.
reopen or maintain the appeal. But are there any, hidden traps, especially thinking about those Section 1206 rules on amendments and evidence we talked about?
Oh, absolutely. This is a classic interaction between appeal procedure and those Section 1206 limitations. Here's the kicker, and it's something people really need to watch out for.
Lay it on us.
If you choose Path 2, filing that second reply brief to maintain the appeal, but you try to include any amendment or affidavit or any other kind of evidence with or in that reply brief.
Yeah.
The rules, specifically 37 CFR 41.50A A2, say it will be treated as a request to reopen prosecution before the examiner, period. Doesn't matter if you intended to maintain the appeal.
Whoa, wait, so just trying to slip in some new claim language or declaration at that point automatically kicks you back into prosecution, even if you filed the paper saying maintain appeal.
That's exactly right. It's a critical procedural point. The system basically says, look, if you're adding new substance now, that needs examination, which is the examiner's job, not the board's appellate review function.
I see. The board reviews the record that was appealed, plus the arguments about it, adding new stuff, changes the game.
Precisely. And that ties right back to why MPS Section 1206 is so strict about when you can file amendments or evidence after the notice of appeal. It's about keeping the appeal focused on the record that was finalized for review.
That makes total sense. And Section 1206 even warns you, right, don't stick non-admitted amendments in your brief. They have to be separate papers, filed at the right time.
Absolutely. Timing is everything. Section 1206 gives this example. Say you file your main appeal brief July 14th, then you file an amendment August 19th, then make a corrected brief September 19th. That amendment from August 19th. It gets judged under the post-brief rules, which are stricter.
Not the pre-brief rules.
Nope, because the initial brief was filed July 14th. If you wanted the slightly more relaxed pre-brief consideration under Section 1206, that amendment needed to be in before July 14th.
Wow, okay, very specific timing. So let's say you do manage to get an amendment or affidavit in properly, maybe before the brief, according to Section 1206, or maybe something comes up after appeal. Does the examiner decide if it makes the case allowable?
Yes. If an amendment or affidavit is properly submitted following all the rules in Section 1206 and the examiner looks at it and thinks, okay, this actually overcomes all the rejections, they can enter it and allow the application.
And if not?
If they don't think it puts the case in condition for allowance, they have to issue an advisory action that basically explains why they're not entering it or why it doesn't overcome the rejections. That's another key procedure outlined in 1206.
Got it. Okay. Let's shift gears slightly. Moving away from remands for a substitute answer, let's talk about another scenario involving a board decision mentioned in the source, the one under 37 CFR 41.50b.
Yes, where the board affirms a rejection but calls the affirmance non-final.
Exactly. What does that mean? The board agrees with the examiner on a rejection, but it's non-final.
It means the board upheld the examiner's rejection, but they've identified something specific, maybe an issue the examiner raised that needs a bit more development, or a new point the board itself is making, and they want to give the applicant one specific shot to address just that point.
So it allows for more prosecution.
Yes, but it's limited prosecution. It's strictly only on the specific ground of rejection made non-final by the board under 41.50b. Very important. The original rejection that the board actually affirmed, that's not open for argument anymore at this stage.
Okay, so you can't refight the main battle the board already decided. You only address the specific narrow point they flagged under 41.50b.
That's the idea. Now, interestingly, the source does note that sometimes, by successfully tackling that narrow 41.50e rejection during this limited prosecution, you might incidentally also overcome the original rejection that was affirmed. It's not the direct goal of this limited phase, but it can happen and could lead to allowance.
Okay, so what happens after this limited prosecution round wraps up? What are the possibilities?
Well, a few things. Best case, you overcome the 41.50b rejection. Maybe it resolves everything, and the application is allowed.
Nice. And then it doesn't go back to the board.
Correct. Allowance means the process ends there.
Yeah.
Another possibility. The application gets abandoned during this limited prosecution for some reason.
Also doesn't go back to the board.
Right. Abandonment also stops the process. The third scenario is the key one for procedure. The 41.50b rejection isn't overcome, and the application isn't allowed or abandoned.
Okay. And if that happens, if you fight the 41.50b point and lose, basically,
then the file has to go back to the board.
why?
So the board can issue a new decision. This decision formally makes their original affirmance final. They essentially close the loop they opened with the 41.50b non-final action. This applies in ex parte re-exams too, by the way.
Okay, so the board just brings it back to finalize things. Now, if that 41.50b rejection wasn't overcome in that limited prosecution round, can the applicant appeal that rejection?
Yes, they can. If you didn't overcome the 41.50b rejection, you can file a second appeal.
A whole new appeal.
Kind of. But the source is very clear. This second appeal must be limited only to that 37 CFR 41.50b rejection. You absolutely cannot use this second appeal to try and re-argue the original rejection that the board affirmed in the first place.
So that first affirmed rejection is really done unless the 41.50b process happened to fix it.
Pretty much. The scope of that second appeal is very narrow. And one last crucial timing point the source makes about this 41.50b situation.
What's that?
The deadline for filing a request for rehearing on the original affirmance or for seeking court review of it doesn't start running from the board's first non-final decision. It runs from the date of the board's second decision, the one that made the original affirmance final, after the whole 41.50b prosecution attempt finished.
Wow, okay. That really paints a picture. The appeal process isn't just a straight line. You can have these loops back to the examiner driven by remands or these specific 41.50b decisions. And all along the way, those MPP Section 1206 rules about what amendments and evidence you can file and when are super critical.
Absolutely. It shows how these procedural details, like the strict deadlines and content rules in Section 1206, or the specific conditions of a 41.50 situation, they really shape the whole appeal. Missing a deadline, trying to file evidence at the wrong time, it can close doors.
Yeah, it forces tough strategic choices. You really need to pay close attention to the MPE rules.
Meticulous attention, really, especially with post-appeal submissions.
Indeed. Well, this has been incredibly insightful. A special thank you, as always, to Mike Shepard for organizing this entire audio series. And now, the disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and Notebook LM, and may contain errors or omissions. It is provided for general, educational, and informational purposes only, and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner. So finally, here's something to think about based on our discussion today. Knowing just how tight the rules under MPP as Section 1206 become once you file that appeal brief. How does that change how you might prepare your case before you even decide to appeal? Or how you handle amendments before that brief goes in? Maybe it emphasizes getting your best claims and evidence on the record much earlier. Definitely something to mull over. Join us next time for another deep dive.